Okay, so Robert, the trial starts tomorrow.
Yeah, presumably, because there was a motion to dismiss because what Chauvin has been charged with. He was the officer who had his knee on George Floyd's back and neck, and is considered the principal culprit for the death of George Floyd. And this trial will decide that. What he was originally charged with was 3 different criminal charges. The lowest level one was second-degree manslaughter, which carries up to a 10-year sentence. Average sentence is 2 to 3 years in Minnesota. The second charge was third-degree homicide, which carries up, I believe it's either 20 or 25-year potential prison sentence, and usually you get double-digit time. And then the top charge, second-degree murder, which was, in this case, felony murder, which carries up to a 40-year prison sentence. Usually you get more than 20. And so the third degree, the defense moved to dismiss both the second and third degree murder charge. The court denied the dismissal request for the second degree murder charge, granted it for the third degree murder charge. There was a parallel case that came up from a couple of years ago where a police officer in Minnesota had shot an individual who was completely unarmed, shot and killed her. And the question had just gone up in February to the Court of Appeals as to whether or not he could be charged with third-degree murder. And
is that the Minnesota case with Noor?
Yes, that's Noor.
Okay.
So it hasn't got the same public attention, maybe because because it doesn't play into certain convenient narratives that the press likes to push. But frankly, it was a more egregious case from my perspective.
This was I'll just give the brief overview. This is the cop. A woman calls the cops. Cops show up. The Noor is the police officer in the passenger side, who I believe fires through the driver's side window when he's startled because the woman who called the police approaches the police car. The woman was an Australian woman, passed away from her injuries, and I guess the matter got to trial 2 years later.
Correct. And she was unarmed, and he admitted that he knew she was unarmed. He just got startled. Now, I do have, in my view, this case is a second-degree manslaughter case. It's not a second-degree murder case or a third-degree murder case under traditional interpretations of Minnesota criminal law. The way our criminal law systems work everywhere in America, is you have different elements. You go up the scale. And if you have a situation where second-degree manslaughter and third-degree murder require you proving the exact same things, that doesn't make sense because one carries a much harsher prison sentence than the other. And so what should be the case is you have one level of intent for second-degree manslaughter, another level of intent for third-degree murder, another level of intent for second-degree murder. In this case, second-degree manslaughter is called criminal culpable negligence, but for constitutional reasons, it's effectively the same as gross recklessness. So you have to know a substantial risk that your conduct is going to cause a person to die. And then you go up to third degree murder. And what it looks like is it's meant to be wildly reckless conduct. In other words, somebody that's driving a car through a crowd of 50 people, somebody who's shooting randomly into a situation, and that's why it elevates it. They want to discourage that conduct, that when you're not just threatening one person, but you're threatening tons of people, then you face a higher criminal penalty. That's the way our criminal laws work in general. And then you have second degree murder, which is felony murder, which traditionally you're committing armed robbery and somebody dies in the commission of it. When there's the kind of crime you were committing had a particularly high risk of a death, and death occurred, and so you're responsible. What's unusual here is I've never seen a case where they say that the felony murder charge isn't that he was committing a different felony, it's that his assault led to the death. I've never seen that prosecuted before, and it makes no sense because then you're duplicating the charge. By that definition, almost every second-degree manslaughter could also be charged as second-degree felony murder, and that's what's not supposed to happen. So I think that now the judge has sustained it for now, but I think on appellate review, if the courts are willing to actually look at the law, which will always be a big issue in a politicized case like this one, I don't think that the allegations of the indictment suffice to meet what second-degree murder is supposed to be.
Okay, and actually, before we even get that, let's back up just for 2 seconds. The trial that's scheduled to begin tomorrow is only for Chauvin. It's not for. Are the other 3 officers charged?
Yes, they are, with aiding and abetting.
Okay.
So the first issue was the motion to dismiss. The district court denied it for second-degree murder. So second-degree murder and second-degree manslaughter were scheduled to start Monday, with jury selection starting Monday. However, he had dismissed the third-degree murder charge, but because of the Noor case, the Court of Appeals reinstated and said the court had to take another look at whether the third-degree murder charge should be reinstated in Chauvin's case. And there's always a possibility, if the court were to reinstate it, the defense may move for a continuance of the trial date. We'll see but I don't think the court's going to, because that Noor decision is going to the Supreme Court. And if the Minnesota Supreme Court applies, it's the Court of Appeals decision in Noor made no sense. They're violating the core rules of criminal law, which is different crimes, different elements required. You can't have a situation where the same conduct fits two different crimes and the same elements. You could have the same conduct find different elements by the jury, but not the same elements. I mean, what's the point? And they dodged. The Minnesota Supreme Court had plain language on this that said third-degree murder could not be just in its jury instruction interpretation. It could not be targeting just one person. And they're like, yeah, but that's in the jury instruction context. It was the dumbest decision I'd seen. It's a politically motivated decision, or just bad interpretation, whichever it was in the Noor case. Now applying it in the Chauvin case. And so I think there's problems with trying to reinstate it. I think the case should go to trial on is second-degree manslaughter. It may go to trial on second and third-degree murder as well. Now, the severance is interesting. The other defendants moved to sever the case because they were charged with aiding and abetting 3 other police officers.
And that is to say that if Chauvin gets acquitted, then they don't need to go to trial.
Oh, no. They can still absolutely go to trial. His acquittal will not impact them. But the prosecution strongly opposed the severance. And I found that strange, because if I was at least in Chauvin's case, I would want the other defendants there, because the other defendants' conduct is far less culpable. You have a bunch of other lawyers who can present cross-examination and argument, and some of those police officers may testify, effectively making it unnecessary for you to testify. So because of their exclusion from the trial, exactly what comes in evidence-wise is probably going to be tougher from a defendant perspective, in my view. But the severance was granted so that their trial's not until August at this point. Okay. Now, go ahead. Give
me one thing. I did just before it disappears. Chris Pavlovsky, who is the CEO of Rumble, says nearing 200 watching live on Rumble. We are still short on features, but glad to have Viva testing Rumble's live stream in its early days. Chris, thank you very much. First of all, for the super chat and for the function. It's people very much appreciate it, because people are looking to find alternatives to YouTube. But before we even just back up 1 second, if Chauvin, why would you not move to separate? If Chauvin is acquitted, he's found not guilty of the criminal accusations. How then could the other defendants be found guilty of aiding and abetting if there's an acquittal in the main charge?
It's inconsequential. I mean, I know that kind of doesn't make sense to people, but it's how you can be convicted of conspiracy and all your other co-conspirators get acquitted, right? See, often co-conspirators are not even prosecuted. So they'll get a second bite at the apple if they lose the Chauvin case. Now, I think the case against the other 3 cops is even weaker than the case against Chauvin. But the other motion that was brought pre-trial was a motion to transfer the case to at least have a different jury pool, or transfer it out of Minneapolis.
Yeah, some people in the comment, I didn't bring them up, but said, good luck finding a fair jury. We've talked about jury selection in previous streams. What is going to be the process? How long are they going to have to select the jury? Is it going to be weeks, days, or hours?
Well, I think basically after the Enron case, it's going to be very tough for any defendant to transfer a case for venue purposes. And so it wasn't a big surprise that this court turned it down. But to a lot of people in the public, they find it very questionable how, when you've had a city torn down by riots, when the potential jurors are going to be walking into a barricaded courthouse with fences and walls everywhere, where there was a shooting, I think, yesterday at the George Floyd Memorial in Minneapolis. So, I mean, it seems a bit questionable, in my view. If someone is clearly guilty, find a better venue. I mean, what's so hard about venue? I think it's problematic to try this case in Minneapolis, but it's going to happen.
Hypothetically, if you change the venue, how far do you have to go? Do you go to another city? These are federal.
I can tell you why the prosecution didn't want a venue transferred, because two prominent police abuse conduct cases, the Rodney King case and the Diallo case out of New York, were both transferred. Now, in that case, in the LA, they just transferred it from LA out to the Valley. In the New York case, they transferred it to upstate New York. But in both of those cases, many observers, that they end up all acquitted in the state criminal trials in the Rodney King case, all acquitted in the Diallo case where they shot the guy, I think 41 times or whatever it was, unarmed guy, immigrant from another community just walking into his home. So, I mean, in my view, both of those cases more factually egregious than what we have here, though probably many people don't know that because so many facts have been excluded from public disclosure about this case. But yeah, so it could be like normally what they would just transfer it somewhere else in just anywhere in rural Minnesota. So you wouldn't have to go that far out. But basically, you within an hour of where the courthouse is currently, you also could just expand the jury pool to include jurors from there under these circumstances. But that's been denied. Now, one advantage from a defendant perspective of a case not being transferred is that what a court should do to substitute for pretrial publicity is give you much better voir dire than you would normally get. Much better jury selection. Voir dire just means Latin to speak the truth.
You're going to get nailed in the comment section. I think we say voir dire.
Well, that's how the French. That's probably the proper pronunciation. But in Tennessee, we say voir dire. So it depends on where you're from, of course, because it's Latin. It's not native to our language. Not really. And so part of that, but you should get much better jury selection because there's two areas where you have to do meaningful jury selection constitutionally. One is if there's been pretrial publicity, and secondly, if there's issues of racial prejudice involved. Those are two areas the Supreme Court recognizes there have to be detailed questioning. In the Snipes case, for example, based on various things I filed, it ended up being a lot of pretrial publicity about racial prejudice. And so the judge who said that he was going to pick a jury in an hour had to spend 3 days. State courts are usually much better at jury selection than federal courts are. In fact, tons better. It appears in this case there has been both a written juror questionnaire, which I always recommend because it gets you information you won't get otherwise, and then you get to follow up in person. Now, they're doing this under COVID protocols, so it's going to be interesting. I don't even know how they're going to seat the jury, given they're supposed to be socially distancing. So, I mean, I have problems with the idea that you can have a fair trial under social distancing rules in modern courthouses because they're not equipped to have jurors sit 6 feet apart. You end up with the jurors like sitting in the gallery. I mean, that creates all kinds of issues. It's just, I'm not a big fan of it. But again, the court's, marching forward on this. And so that's what's going to happen. Now, here's the hard part for picking a jury in this case. You need jurors from the defense perspective. Prosecution perspective is never hard to pick a jury. 9 times out of 10, they're already in your pocket. As a prosecutor, the prosecutor in the Snipes case told me why he loved Miami. He said, all I got to do is point to the flag, point to the Bible, point to the defendant and say, convict. And he thought Ocala was going to be that same community and, just didn't go for him the way he thought. That's how that, so you get detailed voir dire. Here this is my guess. Now, presumably they've done focus groups. They, I always recommend people like the behavior panel to be involved in jury selection because they can sit there and watch all the body language and get a read on things, on all the subtle unconscious communication. Most lawyers do horrible jury selection. They project their own prejudices on the jury. They, just read John Grisham. He has some of the dumbest takes on jurors that exist. And I'm a huge John Grisham fan. It's in order to, what you want here is really a unique mindset because people are going to come in with big biases, big biases. And ideally you want a jury that's heard as little as possible about the case. I know people think, man, that's going to be a miracle. Not so much. People will be surprised how many people pay absolutely no attention to any press whatsoever. So you want someone that's not influenced by the press, ideally. The second type you want someone with a unique mindset who's willing to be skeptical of the government and deferential to police. That is a very, very hard combination to get. because anybody is usually skeptical. Because here you're going to have the prosecution and the coroner and police experts get on the stand and say, this guy committed a crime. This guy committed all these crimes. And in order to rebut that, you need someone who's going to be willing to be skeptical of the prosecutor, skeptical of the police witnesses, skeptical of the coroner, but deferential to police, because normally that personality that's skeptical doesn't like police, doesn't trust police. So that's the hard combination that they're going to need to get. We're not going to know much because apparently they are going to videotape the audio of the jury selection going on, but we won't see the jurors and we won't see the questionnaires. So we'll have no idea how good or bad the jury is, us that are observers. And so we'll find, but I think he needs a unique jury. I think he can get it out of Minneapolis, but I think it is an uphill thing to get.
2 questions. First question is, you're going to have a questionnaire to fill out. I have no idea how this works. Does counsel, defense, and prosecution work together to prepare it, or does only defense have the luxury of preparing it? The written questionnaire to test them, is it generic? Is it done bilaterally, or is it done unilaterally?
Has to be approved by the court. So the court decides what questions get asked. The court controls everything with the process. So the court, usually you can propose questions, both sides, but the court decides what questions get asked, how they get phrased, how many get asked, all of that. Then when you're on and then some courts, this state court probably will allow the lawyers to ask questions of the jury. In federal court, you almost never get to do that. Now, what's interesting about the Roger Stone case is it has cleared up an area that's been occasionally confused about the issue of what kind of research you can do on the jury. So, like in the Snipes case, I had the files of every human being that could appear in the case, digitally accessible to me, so that I didn't have to look them up after I got their name. But at the time, there was because here's the controversy: you find out somebody's a juror, you go and Google that person. You come across their Facebook or Instagram or social media feed. Well, under some ethical rule interpretations and some technologies, when you look at that juror's file, the juror gets notified of it, their social media page. Is that illicit contact? This is what they blew over in the Stone case. They're like, why didn't you look at everything? It's because for years, defense lawyers have been warned to be very careful what they look at and when to look at it. But now that court said that, and said it's your ethical duty and obligation to look at it, I don't want to hear any more courts complaining about this. Because these days, your social I'm sorry, go ahead.
No, I was going to say that for people who may not be aware of this, you probably are, but you can see it, for example, on LinkedIn, when someone views your profile, unless they've turned that feature off and it says someone, you can see who's been looking at your profile. So, and you make this mistake as a lawyer exactly once, because you don't even have to do it for an opposing party or ethical issues. You just might want to know who you're contracting with, who your client is contracting with. And when they see, the other guy's lawyer viewing their LinkedIn page, well, then their hackles go up in all respects. So for anybody who doesn't know that, life pro tip, turn the function off. But and now what is the status now? Are lawyers allowed doing it, or is it still considered illicit contact, which is why lawyers farm out that work?
Increasingly, it's recognized as permissible, and the Stone case sort of solidified that, because the court was like, it was up to you as lawyers to look up the jury foreman's entire Twitter feed. Okay, I'll take that as a green light henceforth. And sorry, I not hear any courts complaining. Don't turn around and say it's your duty and ethical obligation, or it's malpractice if you don't do it, and then turn around and say it's unethical if you do it.
And for anybody, people may not know even what we're talking about in the Roger Stone case. That was the case in which the jury forewoman, who was the forewoman with a large degree of power, I guess, and influence over the jury, it was later revealed had posted numerous anti-Trump, I guess to some extent, maybe Roger Stone by extension. I don't want to oversell it, but she was quite political on Facebook, and it all came out afterwards. And on
Twitter, I think, too.
On Twitter. And she apparently was not transparent on the form that she filled out, but ultimately all of it without consequence. It just colored people's interpretation of the impartiality of the jury. So that's the context for what we're talking about.
And the prosecutor in court's excuse for the jurors, what appeared to be misconduct to me, was, it's up to the defense to have found that information. And I was like, interesting. So now if you're smart and sophisticated, you have a whole team. You have a behavior panel. Now, sometimes cost is obviously a factor, but you have a behavior panel type people involved. You have other professional jury consultants involved. You do forensic handwriting analysis on their handwritten answers, and you have a Richard Barris type, the People's Pundit, who has huge voter files on all kinds of people who can tell you tons of information, what magazines they subscribe to, what their whole social media footprint is. All that information's, people don't know this. It's all gathered on you, folks. You leave a lot of breadcrumbs. But if you're a good lawyer, you'll have researched that. And by the standard of the Stone case, you almost are ethically and professionally obligated to now. And that will give you a big, big path. I remember I had a big case against Wells Fargo, and I employed every resource we had, and we picked a great jury. And once the Wells Fargo lawyer recognized who the jury was, he immediately started trying to sandbag the case, accused me of discriminating against white people, which was funny. But he realized, hold on, that this jury pool is exactly the wrong jury he wanted. That case settled soon thereafter. He actually tried to blow up the case, do an inflammatory opening statement, hoping I would move for mistrial so he could get a new jury. I did not move for mistrial very quickly for that reason. But yeah, so but I don't know how good it is. Most defense lawyers do a poor job of jury selection. So, but that will probably take 2 weeks. We probably won't get into evidence until the end of March.
Oh, 2 weeks. Do we have any idea what the evidence is right now? Like, we do know that there are 2 coroner reports that, from what I understand, say 2 diametrically opposing things.
Kind of. So here's the backstory. Like the evidence, the prosecutor's presentation, opening statement's really kind of basic. Now, here's another fascinating thing. They've hired outside private counsel to be the prosecutors. So it's not the attorney general. It's not the district attorney. They went out and hired 2 of the top private trial lawyers in Minnesota. I have never seen this before. Now, personally, I would love it if private counsel were prosecutors like they do in the Australian system, because there would be more obligation on them to be ethical and professional. But to do so just here shows you how much resources they're dedicated to convicting Chauvin. I mean, he's facing much more sophisticated counsel than if it was just the local DA's office or just the attorney general's office. He's facing the best trial lawyers, plaintiffs' lawyers, corporate lawyers, and state lawyers all working together against him. But their opening statement's relatively basic. It's what the media narrative has been, and it's that Chauvin came in, put his knee on the back of the neck of Floyd for 8.5 minutes. He did so even after Floyd, for several minutes while Floyd was not moving. Did so even after Floyd said he couldn't breathe for several minutes. Did so even after another police officer said, shouldn't we roll him over? What about rolling him over? And did so even though current training protocols in Minnesota required that or recommended you turn the person over once they're no longer a threat to be violent or anything else. So that's basic presentation. Now the defense presentation for the top 2 charges are kind of legal, because there is no felony murder here in my view, and they have, I think, a very good legal argument on that. And depending on what jury instructions they could get, they could win by just saying there's no other felony here. So this just isn't felony murder. And 3rd-degree murder, if that's reinstated, doesn't fit because this was justice to this individual. It wasn't wildly reckless conduct.
Sorry, actually, to stop you there, to simplify something you said before, I think. So the idea of felony murder is you're committing a separate act from assault per se. So robbery, I'm trying to think of something that do not involve assault.
Oh, honestly, it could be any of it. It can be drug deals. It can be, you're just committing a felony period, which a person dies. That's all they need. I mean, in my view, felony murder is a grievously abused criminal statute. People get charged with felony murder that didn't have anything to do with the person's death. So my thought was, like in the Arbery case, my understanding is their felony murder theory, and I assume they were doing the same here until I realized they weren't, was that they had kidnapped a person and then the person died in the process of a kidnapping. That's an example of classic felony murder. I've never seen them say, I mean, by their definition, okay, I have a gun, I shoot it at someone, and that's both assault and murder, I can charge felony murder. It makes no sense. It makes a joke of the Minnesota criminal statute.
So that's the interesting question. So the idea would be that if in the ordinary run of criminal law, if you end up killing someone during an assault, it can be either murder, manslaughter, or I guess murder or 2nd degree.
Right.
If it's a 2nd degree, this theory that it could be felony murder.
Second-degree manslaughter.
Second-degree manslaughter. So the idea here would be why you're saying this makes no sense is if you turn second-degree manslaughter into a situation where you can also then just go with felony murder, you've effectively unwritten second-degree manslaughter.
Exactly. You've negated the entire purpose of the criminal statutes, which is to treat different conduct differently. If you can treat second-degree manslaughter as indistinguishable from felony murder, that's a problem. They've also done the same thing now with third-degree murder. Because once you understand that second-degree murder, even though it uses the language of culpable negligence, for due process reasons, this goes back to Henry Winship and other cases, requires a certain level of criminal intentionality has to be established to prosecute and punish people. We generally don't allow negligence to be prosecuted criminally. Is that it has to be you read the definition in the Minnesota statutes, it's identical to how they're now defining third-degree murder. It's identical. There's no difference in the elements now. None. Because both of them are substantial risk, according to the court's recent interpretation, substantial risk that you're going to inflict harm on someone, that you could cause someone's death, substantial risk of great bodily harm or death. It's now identical, which doesn't make any sense to me. So I think they have good legal defenses on second and third degree murder that might translate to jury instructions that are favorable to them at trial. As to the second degree manslaughter, a lot of the evidence for the defense is evidence most of the public has not seen. So most of the public does not know of the background of of Floyd's background in general, which may or may not come in evidence-wise. So the defense perspective is going to be this. George Floyd was had a long criminal history, a long violent criminal history, including armed robbery, put a gun to a woman's stomach. There's some misinformation out there that she was pregnant. I haven't seen any evidence that was the case. But how much of this evidence comes in is an open question, because the key is going to be, how does the cop say, what is Chauvin knew Floyd before, apparently. So it's possible that Chauvin can testify he knew of this history and that this is why he approached him as a uniquely dangerous person. So part one is the extensive criminal history of Floyd. One of the other detectives' lawyers wanted to introduce a 2019 arrest of Floyd in Minneapolis, where he employed similar tactics. And the defense theory in that case was the reason why that 2019 arrest video was relevant is because it shows what their argument's going to be, is it shows Floyd using, I'm scared, I'm afraid, I can't do this, as a tactic to try to both prevent arrest and get rid of inculpatory evidence. And because he almost behaves identically then to how he behaved now. So those two, but whether that comes in evidence-wise, big open question. Now, sorry.
No, I was going to say there's two things. This is a discussion we had way back, and I think I've had it with Nate and on civil law as well. And it was something about Candace Owens said a while back, that there are two different things here. As far as I'm concerned, the criminal history of the individual can become relevant to the incident, as you said, pretty much if and only if it was factored into the rationale of the cops in approaching him. The fact that he had a criminal history in and of itself, if they didn't know at the time, is irrelevant.
Correct.
What comes into play, the drug use, et cetera, where the drug use, whether or not he was on drugs at the time, typically can explain a few things, but where it will be determinate here is if the intoxication was a contributing factor to him passing away from the knee to the neck, which might have otherwise not caused that reaction in somebody else. Then it becomes a legal question. Regardless, you take the victim in the state in which they come, and so if he's high on drugs, the policeman should know better than to administer something that is probably not ideal to administer in any circumstance, but even more so to someone who might be high on methamphetamines or whatever he might have been high on at the time.
Yeah, that'll definitely be the prosecutor's argument. The defense side of the equation will I'll get to. What is likely to come in is the video of the whole arrest. Even though Chauvin was not there for part of the arrest, so there's a question as to whether all of it will come in. But there it appears that one of the other detectives officers was able to show that what it appears that Floyd was doing was two things at the time of the arrest. That while he's saying he's afraid for his life, and because here's the core narrative for folks out there from the defense. It's going to be, why didn't they take George Floyd? Why weren't they like, oh my God, this poor guy, he's saying he can't breathe. Why didn't they immediately step back? Their explanation is going to be he kept making up different excuses at different times for why he couldn't comply while he destroyed evidence and resisted arrest. That's going to be their narrative. And they do have evidence for it that the media has not generally publicized. In fact, the prosecutors went to great lengths in this case to try to keep the 2019 arrest video from being released to the public, went to great lengths to try to keep the body camera evidence from the other detectives didn't want that released to the public. Highly unusual. And they've actually gone to great lengths to request that this trial not be video broadcast, which is a little odd. But what it tells you is there's a whole bunch of evidence that prosecutors know makes their case look a lot weaker than the ordinary person knows out there.
Well, an interesting thing though, if there's going to be evidence to the effect that Floyd was making up excuses, that if he, and the idea being he could actually breathe, he was just saying I can't breathe as an excuse. Well, that might make it, in my mind, even more damning of the causal relation between the knee and the death. No, I mean it's.
What do you mean?
Well, if he says if he could in fact breathe, and he was just making up, he was using it as an excuse to get them to stop doing what they're doing, and then he did in fact die as a result of what happened. I mean, what's going to be the rationale that he could in fact breathe, but somehow he died of something else totally spontaneously?
It's not so much an objective factor as to what caused his death in terms of that theory of defense. That theory of defense is all subjective state of mind. That why, like Piers Morgan had this interview with one of the criminal defense lawyers where he got to virtue signal and grandstand and attack the lawyer, but largely because Piers Morgan doesn't know the core facts in the case. To him, it was clearly the best evidence of intentional homicide was the fact that they heard him begging for his life, saying he couldn't breathe, and they didn't do anything. So if you're the defense, you need to contextualize, why don't you interpret that as, oh, we got to take emergency action? Okay. And from the cop's perspective, it's going to be, the guy's been giving me different excuses the entire time. 1 minute he thinks I'm going to shoot him. The next minute he can't, he's claustrophobic. The next minute he starts apparently saying he can't breathe before he's even on the ground. So though that's what it's about a subjective mentality defense. And for folks out there, I'm not saying what I believe. I'm presenting what both sides are going to present. I don't have an opinion on the case beyond what I've already said. But what's key is if you watch court TV, the lawyers on there, longtime criminal defense lawyers and even ex-prosecutors, have a very different view than what everybody's hearing in the press. And it's because there's a lot of weaknesses in the case that have developed. Here's the biggest one. The study showed that this method of detaining individuals had been employed hundreds of times in Minnesota in just the prior 5 years. And it was unconsciousness was not uncommon, but death was unheard of. So what these officers are going to be able to say is this is commonly employed. We were trained to do, well, this is what Chauvin's going to say. This is how I was trained. This is how people do it around the world. Indeed, people are put into that position tens of thousands of times around the world by police departments. It's now controversial, but it wasn't that controversial at the time. If you were a civil rights lawyer, you knew it was controversial, but most people did not. Most police officers, frankly, did not. And so that's why they still had it in the manual, and then they tried to memory hole the Minneapolis manual and make it disappear.
That was exactly what I was just about to ask you. Someone in the comment section said that the police station apparently, or the police, wherever it is listed as protocol, removed it from the website as standard protocol. I don't know if that's true or not, but
yes, absolutely. They removed it, and they removed the whole. You had to find it. It took great efforts to find it, but the defense has found photos of training manuals from slides that show worse footage than what happened with Floyd. And here's another parallel to this. The best example of this, the 8th Circuit in 2020 said that you couldn't even sue a police officer who put somebody in that exact position with the legs shackled, with their knees on the neck for 15 minutes, almost twice as long as Chauvin did. And the guy died, and the guy complained he couldn't breathe. The 8th Circuit Court of Appeals said you can't even bring a civil rights case on that because that's within the reasonable exercise of a police officer's duties. So those are things that may come in because police officers track those cases because they're told about them by their union. So if you're sitting on the jury, you've been told that position is horrible. You're putting your knee on a guy's neck for 8.5 minutes. What happens when you find out that's part of training? What happens when you find out that they've done it hundreds of times and nobody ever died? What happens when you find out that the 8th Circuit Court of Appeals said that's reasonable police officer conduct? These are things that the press thinks that if they gaslight the country into not knowing, that somehow you can keep it out of a jury trial. And you can't keep it out of a jury trial. I mean, the court could try, but the court has shown no inclination to go that route.
No, but you can't necessarily keep it out of the jury trial. But if you keep the jury trial off the airwaves, then you can keep that information out of the the knowledge base of the general public, so they can be outraged if and when there's an acquittal that the View gets to freak out over.
And this attorney general is the guy who put a photo of him with Antifa's book and bragged about it. That's who this attorney general is. So and this is a case going back to the coroner's report issue. So there's intent, legal issues on second and third degree murder. The issue about whether it's reckless homicide is they have to show that Chauvin subjectively, there was a substantial risk of death by him doing what he was doing. The evidence that it wasn't is that this was custom and procedure that had been approved of by federal courts, that he had employed for 15 plus years, that nobody in Minneapolis knew of a single death relating to it or being caused by it. So that's his best defense. The best counter to that from the prosecutor's perspective is going to be that once the person is no longer a threat, you're supposed to roll them over on the side, according to that Minnesota train. That's his biggest evidentiary hurdle.
Yeah, that and the three other, I don't know which ones, one of the three or two of the three or three of the three other officers expressing concern at the lack of responsiveness. And then Chauvin continues for a few more minutes.
It might be a causation issue, right? What if he was already dead by that point? So if he was dead by, say, minute 5, that he's on his neck, does anything that happens after minute 5 matter? Probably not, right? Yes. So the other big issue in the case is going to be causation. So there's two issues with it. One is that this particular method rarely leads to death, and that it didn't have the normal indicia. You didn't have a crushed. I don't know all the medical terminology. You won't pretend I do, but I just looked at the common things they usually use to prove that the knee on the neck caused the death. Those are not present here. Now, nor is the normal things that are assigned to ODs. So he had a fatal level of fentanyl in his system, and it appeared he did something called a goofball. It also appears they have video footage. Apparently, one way he was trying to get rid of the evidence, because he was trying to get rid of the counterfeit bills because they found him crunched up later in the car when he was trying to buy. I think he was trying to buy time. I think that's what the evidence the jury will believe he was trying to do that, which it's going to change the filter on things a little from what the media narrative has been. It's why the media has almost never covered that fact, that they found crumpled up, like, why didn't he put his second hand on the wheel? The reason why the cops started getting really nervous, he's only putting one hand on it's because he was trying to get rid of the counterfeit bills, because they find him crunched up later in the car. But the other thing he apparently did is they have a slow-mo photo of, it appears he took a shot of fentanyl and they have him in his mouth, that he was trying to do that quickly before they could find it on him. So he may have done the shot or done the drug right at the time. Now, the thing with all that is, so these goofballs can cause the same kind of death that he suffered. But normally you see other physical indicia of it. So there's going to be a lot of medical experts on both sides in this case. I think the prosecutor has 4. They have, like, the coroner. Now, the issue, as you note, there's an issue with the coroner, because the reason why the Minnesota Minneapolis DA's office is not bringing the prosecution is because they decided to do a secret meeting with no witnesses present with the coroner. And from a defense lawyer perspective, usually that's to help make sure the coroner comes to the right conclusion. Because other people that have looked at this, even people that think Chauvin should be convicted, that are in the medical community, that have been on YouTube or other media places, have said that if all you did was look at the paperwork here, the toxicology report and the autopsy, you would probably conclude drug overdose. It's only when you've seen the video or know about the video that you conclude that's the reason. Now, there was a second autopsy done by Floyd's family that says they believe there's more physical evidence of it being a direct cause, of the knee on the neck being a direct cause, than the coroner said. So, but cause of death is going to be big, because in order to show convict him on any of the charges, they have to show that he was a substantial factor in the death. Doesn't have to be the sole factor, but does need to be a substantial factor. And given the level of drugs in his system, there's going to be an inference. And the best evidence they have, really, in my view, isn't so much that. He also had a heart condition, other issues. It's because it's the evidence that this is very rare, that a knee on the neck that doesn't cause certain injuries to the neck, to the breathing mechanism here. It's very rare that causes death. That's probably their best evidence. Defense's best evidence is going to be he didn't show the physical signs of an OD. Face didn't turn. He didn't go limp. His face and fingers weren't, nothing was turning blue. some of those indicators that are commonly present. But it appears what he did was called a goofball. I didn't even know what this thing was, but I'm illiterate in the drug world. I don't have Hunter Thompson's skill or experience in that regard.
But okay, here's the thing to back it up. If anybody in the chat, if this is not correct information, then do correct. Is it accepted from both sides that he had a lethal amount of drugs in his body, or that he just had elevated amounts?
No, there was a fatal amount, but not that it caused the death. That's where the dispute is. Because it wasn't just fentanyl. Fentanyl was the level he had in fentanyl, and fentanyl is an incredibly dangerous drug. I mean, 80 to 100 times worse than heroin in certain contexts. The level he had in him, like as soon as people saw the toxicology report, and this is something else they tried to suppress for a long period of time, people were like, whoa. People who are much more knowledgeable in that area than I am were telling me, oh, I'm sure the drugs killed him. But then when I was researching what the likely evidence would be, seeing a lot of medical community people saying, well, he didn't show the physical indicia that you would normally see from a drug overdose. Now, there was some sort of breathing condition they were describing. I didn't dig enough into it that could fit the description. But there's basically evidence inconsistent with both theories of death. In other words, both with it, there should be certain evidence that's not present if the knee on the neck caused the death, and there should be evidence not present if the drug overdose caused the death. And so I think, but it's enough to probably raise a reasonable doubt if you have an impartial jury. I think if he got a truly impartial jury, long story short, I think Chauvin would get acquitted of all three counts. I don't know if he will get such a jury.
Well, before we get into which way the jury will be impartial or partial, I should say, going back to the eggshell defense, you take your victim in the state that they come. Is it a double-edged sword to say if they're going to say, I saw him try to swallow the drugs, I knew that he had tried to swallow a goofball or whatever. If the cop's defense becomes, we saw him consume the drugs to hide the evidence, which is why we did this and that, do you have to take someone in the state that they are in if they've just consumed the drugs and treat them differently?
Yeah,
I mean, I know ways, because if he's in a state of, what do they call it? Delirium. What's the word I'm looking for? Excited delirium.
Yeah.
Then he can be even more of a threat, and in which case you might have to use more subduing tactics. If you know that he's just done a lethal dose of something, maybe you need to get him to the hospital right away, but he's not. So does that cut both ways?
Well, it depends on what drug they thought he had. And if they thought it was excited delirium and it was PCP, this, by the way, was the Rodney King defense, that the reason why they kept attacking him was they were saying they had to keep attacking him because they thought he was on PCP and just wouldn't stay down. And remember, that was much more egregious conduct than what happened, at least in my view. I think it's fair to say. I mean, putting your knee on the neck is something that shocked a lot of people. But Rodney King, I think, would shock more people. I mean, eight guys sitting around beating you beating you and kicking you.
If anybody, it's not a video that anybody should see, but we grew up. I mean, we were roughly the same age back then. That I remember traumatized me. I mean, I saw the video. It's very, very little that anyone can use to explain that. But yeah, this did shock me as well. And I say this with not the blindness, but rather the viewpoint that I was still seeing this through the news. I don't know when I became aware of the toxicology report, but I did remember thinking, okay, when both coroners come up with sort of different conclusions, it confirms my theory about experts, etc. But I was not aware of many of the facts when the initial story broke. I suspect a lot of people in the chat are probably learning some stuff that they didn't know either. Most notably, the fatal levels of fentanyl in the system, which I did not know.
I think the two pieces of evidence that favor Chauvin the most are, one, how common this technique was used without it causing death. And secondly, the fact that, I should say three pieces. The second being how much Floyd fought back when he was inside the car, that the body cam footage showed. And then third, I mean, he was physically, it was almost impossible to keep him in the car. And then third was the degree of his toxicology report. The evidence that hurts Chauvin is the length of time he's on his neck where he doesn't appear to be pushing back or fighting back at all. And then the other big problem for Chauvin is if his record comes in. Because I remember when we first talked about this, I said, if Chauvin, if I would be skeptical of Chauvin's intentionality if he has a history of complaints, just because in my experience in civil rights cases and before all the cop, well, if you want to troll me, you have to go to Viva Barnes law.locals.com.
You are
there's no guarantee that I'll read your comments elsewhere.
You are the best at plugging the locals. I'm 10% of your ability to do it, but yes, you can get to us and Barnes in particular.
And then you can troll me about anything you want, take whatever pot shots you want. But but in my experience, I know all the cop folks out there might get agitated, but in my experience, when someone's got a long list of complaints, it's rare that 5% of officers or less have a dozen or more complaints against them. It's just people claim to me it's commonplace. It hasn't been in at least my litigation experience. I have not seen it when I've looked at the records and information and when I've done FOIA requests and the like. So maybe something's changed. Maybe something's unique to Minneapolis. But when I saw that, I was like, I would have doubts. It also might put pressure on him in terms of testifying. He has other risk because he's currently facing criminal tax prosecutions because apparently he didn't file returns for many years. And his wife's got risk. There's probably corruption issues. That's why I think no matter what happens in this trial, Chauvin's done. His ability to defeat all these things, very low. Not only is his job over, he's going to go to jail or in prison on something. And that's why I thought the real person to blame here is, in the end, Attorney General Barr, because Chauvin was willing to plead guilty and do a 10-year stint for this to wrap it all up that would have given him the conviction that he needed rather than gamble on what a jury will do when they see all the facts. The other thing is, I can tell you from doing these cases, jurors get mad when if they have a jury that has been exposed to the pretrial publicity, gets seated anyway, they get mad when they discover they've been lied to by the media. And it starts to make them doubt everything about the prosecution. That's why if I was on the prosecutor's side, I let my weak links of the story come out early so that I see how they get absorbed, see how they deal with them, and I look like I'm the truth teller, the truth giver. I come in with that assumption if I'm a prosecutor, just the opposite of your defense lawyer. But I think people are going to be shocked by it. There's a reason why the prosecutors did not want the public to see this trial. It's because a lot of evidence is going to come forward that's going to raise serious questions about what they originally assumed was true.
Okay, that might do it does it for now for the preview and where things are going to go. I mean, I guess by next week's stream we'll know more and we'll have more to follow up on if there is. I think I've got all the questions out there. If anybody has any more questions that we didn't get to, let me know. But I think now might be time to move on to something along the same lines of egregiousness. Do we do Cuomo? Because I have a few questions that have been driving me nuts.